conflict resolution rather than conflict escalation. So I'm still in the conflict escalation stage, and I let other people do the...
I call it the heart attack avoidance stage of your career.
Welcome to Water Cooler Justice. I'm Chris Robertson, and I've been practicing employment law for over 20 years, helping clients resolve disputes and navigate challenges at work. Today's episode is going to be a little bit different. We're going to be talking about mediation with two of the city's very best, Andrew Monkhouse and Barry Fisher. Managing partner, legal author, law professor, business owner, and community volunteer. Andrew has many roles. In his role as litigator, he took the most employment law cases to trial of any lawyer in Ontario between 2013 and 2023 and has exceptional in-court experience. Andrew is a pioneer in class actions work, having started the first contractor/employee class action in Ontario and the first vacation holiday underpayment class actions. I didn't know that. We are so happy to have you here, Andrew. Thank you for joining us. We're also joined by Barry Fisher. We know Barry is the Dean of Employment Law around here. He's a mediator and arbitrator in Toronto and brings over 30 years of experience as an employment lawyer and legal author, not to mention one of the most often chosen mediators for employment law cases under the Ontario Mandatory Mediation Program. Welcome, Barry.
Thank you.
All right, let's get into it and talk about mediation. So something that a lot of people aren't necessarily aware of is that mediation is mandatory in Toronto. Where else is it mandatory, and why isn't it mandatory everywhere?
Well, it started off with a pilot project in, I think it was 1995, and they introduced it to Toronto, Windsor, and Ottawa. And it was a booming success. And then most pilot projects lead to incorporation into the rest of the province, but that never happened. So here we are, 20 years later, after a successful pilot project, and the provincial government has simply refused to expand mandatory mediation throughout the province. This is something that me and Andrew and many other people have been working for years to try to get to expand. But we live in an absurd world where if you start your action in Toronto, you get mandatory mediation. If you start your case in Newmarket, you don't. So basically we have two tiers of justice. I've worked through various organizations over the years to get it expanded. We've got right up to the doorstep of the Attorney General, because that's the minister who has jurisdiction over it, and it just fails every time. And I don't know why. It's cost effective, it costs the government nothing, it's proven to be successful. It's not politically interesting, I suppose. So we're stuck with this fact that lawyers manipulate the system. If they're in Newmarket and they want to have mediation, they start the case in Toronto, which there's no connection. If they don't like mediation and they're in Toronto, they start it in Newmarket to avoid it. And there's no good political reason why it hasn't expanded. But that's the world we're stuck in.
Yeah, so it leads to some forum shopping, right?
Correct.
Yeah.
Or overcrowding of Toronto courts. I think it's the other way around. I think people want to have mandatory mediation. So the Toronto courts are getting flooded with cases that they shouldn't get.
Well, I'm not filing a lot of my cases in Newmarket, I'll tell you that much.
Well, it depends. I mean, and the rules are specifically set up that way. So you are explicitly allowed, a plaintiff is explicitly allowed to start the case in any courthouse subject to a motion to change courthouse under Rule 13.01. And so people are allowed to start wherever they want, but because the resources aren't necessarily pooled as much as they could be, different jurisdictions, for instance, the HRTO, the Human Rights Tribunal, they are province-wide, but we're still courthouse by courthouse. We're operating like we did 100 years ago. And so when everybody files their case in Toronto or everyone files a case in London because they say they don't have mediation, that causes problematic effects on the system that can deal with the resource allocation problems. So it makes problems behind the scenes. But mandatory mediation does exist, actually. I want to add to that, in some jurisdictions, in some areas of law, I should say, across the province. So for instance, all motor vehicle accidents under the Insurance Act, there's a right of a plaintiff, so the person who's in the automobile accident, to request and force a mediation. Effectively, it's not mandatory, it's single party request. But that's province-wide. So there actually is already a mandatory mediation system effectively province-wide for the most common type of lawsuit, which is motor vehicle accidents. That already exists. So it's a two-tier system with a couple of exceptions. All condominium acts, for instance, they have implied by statute into their acts a mandatory mediation scheme for disputes for condominiums. So there's a patchwork. But as Barry said, you shouldn't have to be guaranteed that you're covered by that patchwork or to file in Toronto, Windsor, or Ottawa in order to get that. So it would certainly clarify things if it was province-wide, because it's been just so overwhelmingly successful. So there's a number of changes afoot. Different tribunals have different rules. A number of federal tribunals have mandatory mediation. So it's a patchwork system at present, and it would be great if it was consistent.
So you often hear that 90 or 95% of matters at mediation you often hear that 90 or 95% of matters settle at mediation. And I heard that we have a broad consensus, at least on this panel, that it's successful. And so one of the things I'm wondering is that your experience? Is it true that many, if not all, matters settle at mediation? And if so, why? What is it about mediation and employment law that has such a high rate of success? Any thoughts?
Well, I'd estimate it really depends on the conditions of the mediation. I'd say that first, right? So private mediations where the parties choose a private, say, non-roster mediator in Toronto. So you're saying, we like this mediator, someone's picking Barry. Probably about 80% of those cases settle. And they seem to settle, from my experience, even if people think they aren't going to settle up front. So people say, we don't think it's going to settle, this isn't a good case, or this is an amazing case, so we're not going to settle. Still, it seems to be about 80%. Now, then, of course, it depends. If a mediator is pushed on the parties or forced on the parties, selected for them, those ratios can go down, and depending on the experience of the mediator, probably as low as 50%. You might be even getting into 40% sometimes. Say the mandatory mediation version in small claims court in Ontario, which is settlement conferences, those might even be 40, 50%. So it does depend on how successful they are, but even 40, 50% is very successful at an early stage in the process. Obviously, you want to be trying to create the environment whereby you're getting those higher numbers, because it lets people make those choices as adults, as decision makers themselves, and not have justice force on them. So people are able to have that party autonomy, and that's really beneficial. Especially the higher numbers. You can't settle every case at mediation, but a very high settlement rate helps with resource allocation.
Let's talk a little bit. I wanted to just clarify a little bit for listeners, roster mediators versus a private mediator. Do you want to talk about the distinction a little bit?
Sure. When they set up the mediation system, they said if you basically can't agree, or there are some people who are on an Ontario roster, when they'll agree to do mediations at a certain set minimum rate. So if the parties can't agree, then you can have a mediator appointed from that roster, or if they want to have it at that set rate. So there's sort of a discounted rate for those mediators on the roster, and I think it's $600 for a half day, and it hasn't increased in 25 years or so since they brought the project in. And so there's that discounted rate of people who are on that roster, and then you can select a private mediator who have their own rates that are effectively market driven in terms of what that is, and that can range from $2,500 for a half day to $25,000 for a half day. There's some you can hire very expensive mediators. It's the economy. You can buy a car for $5,000. You can buy a car for $500,000, right?
Barry, do you want to talk about maybe some of the magic that a private mediator brings?
I wish I made 25 G's a day, but anyways. A little back on the other comments too. I statistically, the last time I looked, about 80% of my cases settle. One thing you always have to remember is mediators, every settlement is confidential, so they can lie through their teeth as to what percentage they settle. Funny enough, I did a follow-up study of my failed mediations years ago, and of the failed mediations that failed at me, 95% of those cases settled. So sometimes mediation doesn't bring about a settlement, but it brings about a narrowing of the discussion, and it settles a month or two later or something like that. So you can't always judge the success pattern based on just did you get a deal by the end of the day. One of the other reasons why mediations in other formats don't work as well is I find it at least extremely difficult to mediate with unrepresented parties. My mediation approach is very evaluative. It depends on both parties having a good understanding of the law. And with unrepresented parties, it's very difficult. So one of the reasons I think small claims court settlement rates are probably lower is because they're often with unrepresented people. Family law, same problem. Any area which has a significant component of unrepresented parties is probably going to have a lower settlement rate. So get a lawyer. Don't do this yourself.
All right. And so I wanted to ask you, Barry, is there a particular, you mentioned the evaluative style. Is there anything else that you sort of bring to the mediation process that you think is sort of unique to your style or that leads to success? And then I'll flip it over to Andrew, and maybe Andrew can sort of give us some insight as to what he thinks makes for a successful mediation process.
The two traditional methods of classifying mediation, and there's variations in between, is evaluative and facilitative. And the main difference, theoretically, although in practice I don't think it exists as much, is to what degree does the neutral, the mediator, bring to the table their knowledge of the product, as I call it, the product knowledge, and how willing is that person prepared to share that. So I'm an evaluative mediator. I say that right on my website. So in other words, I rely on my many years of experience as an employment lawyer and a constant reader of cases ad nauseum. And I bring to the table my experience in mediation. So I can tell when a lawyer is pulling my leg, which is a nicer way of saying BSing me. And I can say, really, I'm not sure a 2-year clerk at Walmart making $18.50 an hour is actually not going to get 24 months notice. I'm sorry, notwithstanding certain demand letters that may or may not say that. On the other hand, I stay within my reign, in my area. I don't purport to do personal injury law because I have no idea what the rules are. Facilitative mediators, on the other hand, believe that the process of mediation is the important thing, and it's not necessarily helpful. In fact, it can be harmful for the mediator to express his or her opinion, or for that matter, have any expertise in the subject matter of the law. I would venture to say, though, most people use a combination of both. This may be a bias here, but most successful mediators, I think, tend to be on the evaluative scale rather than on the facilitative scale for litigious mediation things. If you're talking about a workplace restoration project where people don't get along, then a facilitative mediator is way better. But for sort of wrongful dismissals, human rights cases, a knowledge of the law certainly helps. And I think that's what most lawyers are looking for too.
Andrew, anything you want to add to that?
I think that's right. It's one of the reasons why non-lawyers have struggled to break into being media. A lot of the, not exclusively, but a lot of the most successful mediators of litigation issues tend to be lawyers. There's a couple of exceptions, but they tend to be lawyers who were in the trenches, as it were, fighting out those litigation matters, and then they move on to conflict resolution rather than conflict escalation. So I'm still in the conflict escalation stage, and I let other people do those.
I call it the heart attack avoidance stage of your career.
Right. And that's one of the things that I think a lot of the people who oppose mandatory mediation outside of Toronto, we see those same people who might be opposed to mandatory mediation, they're actually potentially losing out themselves on a potential revenue stream because they don't necessarily realize that some of the people who were opposed to mandatory mediation initially, those people then became mediators and then actually gain a revenue stream later as they become sort of the older, more experienced lawyers or stop even practicing law and just mediate all the time. And so the people who are opposed to it, now I don't think Barry was opposed to it, but some people who are opposed to it actually then become mediators because once mandatory mediation comes in, they're the people that they look to. So it's actually losing out on a revenue stream for them.
Are you implying that people can look out for their own self-interest sometimes and change their political views based on their self-interest? That's a shocking revelation.
Well, I don't know whether it's a political view. I mean, to me, it just seems like common sense. If we can get 80% of employment matters resolved without a trial or without having to go deeper into an expensive civil procedure, why not?
Well, the response to that is a fair one. The number of cases that go to trial probably hasn't changed very much over the years, okay? So to say that mediation stops 80% of cases from going to trial is a fallacy. I practiced for many years before there was mediation. Lawyers still talk to each other. They still settle the cases. The main difference is the timing We settle them faster with mediation. We settle it in 3 or 5 hours as opposed to going on for months and months. And in most cases, certainly employment cases, we do it at an early stage, usually prior to discoveries, sometimes prior to the pleadings. So it is more efficient. But it is misleading to think that cases didn't settle before mediators were invented. The same percentage of cases go to trial, I think, that ever used to.
I'm more focused on cost to my client, right? If I can achieve the same outcome for a substantially reduced fee at an earlier stage in the proceeding, that's in my client's best interest every time.
That cuts to the quick of it. That cuts to the problem of the concern about perverse incentives. So the opposition, no one's going to say, I want to charge my client more, but we do tend to see opposition to mandatory mediation is very often for certain reasons, but behind those reasons is a concern that it might affect lawyer billing. But what we've seen actually is that turns out to not be the case most of the time. And that's why in Toronto, the people who oppose mandatory mediation even say, defense lawyers often tend to be the ones who are against it. They find that their billings have actually, if anything, increased. They have a new revenue stream potentially of being a mediator, but they're also able to cross-sell at mediation. You get to know your client better at mediation.
Yes.
You get to talk about their kids, your kids. You get to say, oh, do you need a will? I have a partner who does wills and estates. Oh, you need your will updated? You get to know them. You get to see if there's other services that benefit them. So it's 3 hours of getting to really know your client and also Barry at the same time. And that cross-selling opportunity and being able to resolve things faster. If you bill your client and then the day before trial, you call them up, you twist their arm, you get them to settle, are they really going to go with you? Are they going to be upset? If you can go take more matters to mediation, have a good resolution at mediation that's just as good for your client, save them money, build up a personal relationship. There's a limited pot, but it gets better services for lawyers. And I think it's very short-sighted to sort of think, oh, I'm going to lose those cases where I billed right up to the last minute and it wasn't that a great case and I took all that money from my client. The clients aren't going to like that and they're going to go to other people. From what we see, it makes more money even for the defense side folks, and it's a better practice overall. But the concern of the change, that does seem to, I have some level of concern that is one of the reasons why people are reluctant to expand mandatory mediation, is that they are worried about their own billings. Not that a lawyer would allow how much they're going to bill to only influence their decision, but it is in the background.
Okay, I'll scratch that itch. So what about contingency fees? Since contingency fees have become legal in Ontario, has that had a meaningful impact on mediation? Barry, Andrew, anybody?
It certainly incentivizes plaintiff lawyers to settle the case at mediation, to put it lightly.
Yeah, I think there's an interesting, obviously contingency fees have that effect that, there's an 80-something, there's certain lawyers, there's an 80-20 rule, right? But I think the market tends to solve on that. If a lawyer becomes known as taking lots of cases to mediation and settling the case, 80% of cases are going to settle no matter what at mediation. But if a lawyer becomes known as taking cases to mediation and settling 100% of cases no matter what, that's going to have a market effect on what other lawyers are going to be offering them or taking them seriously on. So, insofar as it's better for the clients, that's something that can take into account in terms of the fees, in terms of with contingency and otherwise. So we don't really necessarily see, I don't think contingency fees themselves have made a big difference, other than it allows better access to justice for individuals to have the resources to be able to go to that mediation and threaten that they could continue further to be able to get, a better deal at mediation. But the fact that mediation focuses both sides and both parties on it, it's a net good tends to be towards everyone. And of course, as I well know, if clients are upset with their fee, they, even in contingency fee matters, have a right to assess them and have them checked over by a judge. So that's one of the protections that come up in terms of with contingency fees and otherwise. So there's always that escape route there.
The age-old issue, you're selling your house, one agent takes 6 months and you have to show it 15 times and he charges you X and the other guy lists it properly and sells it in a day. Why are you pissed off at the guy who did his job better? It's the age-old problem between effort and result. So.
And I said judge, but I mean judge, or if the parties agree, and arbitrator under the Arbitration Act. But yes, it's that, there are perverse incentives in all parts of law. But the great thing about mediation is that you have a mediator there whose primary interest is to get a resolution. So you have a champion for resolution. So even if both sides, let's imagine a case where both sides are being paid hourly, but even if both sides, if the lawyers might have a perverse incentive to push the case ahead and settle later after there's more fees, that mediator is the advocate for resolution in the room, who can talk straight to the parties and say, well, are you really going to spend $100,000, $200,000, $500,000 going to trial on this, depending on the case? And, there's something where the client might say, well, look, I'll have a resolution instead for that. Because mediators are, to some extent, sort of tell you this, Barry, judged on, do they get deals? So the mediator, the market, if a mediator has a higher resolution rate, if they have a higher settlement rate, that's going to cause people to choose them or not. If you fail at a mediation, you're not going to have a particularly long career as a mediator. And so their incentive is different. They're not paid as much as Barry jokes about wanting it sometimes, a percentage of the overall settlement. That would be, then you have the real estate agent problem about wanting
it's unethical for any mediator to charge a contingency fee.
Exactly. So their only interest is to try and have the experience of the parties be good when they're private mediators. And so whatever that is, if it's giving out pens like Barry does, or giving out little snacks and Halloween candies, or if it's giving out, if it's trying to get a resolution and making people feel comfortable and relating to them, that's their incentive. Because they're after that, if they don't get a settlement, they're done.
Put it this way, if I get a settlement, it's because I'm brilliant. If I don't get a settlement, it's because one of the lawyers was an idiot. The lawyers look at it differently. If I got a mediator, if I got a deal, it's because I'm a good lawyer. I didn't get a deal, I had a crappy mediator. It's the flip side of the coin. I get that.
But so, if you're consistently picking excellent mediators, you're going to have a higher settlement percentage.
Well, I think what happens is
right?
Lawyers choose mediators that they've had a good experience with.
Right. And if you can't agree on a good mediator, keep going until you can.
Well,
right? Why would you ever use the roster mediator in an employment dispute?
Yeah, I usually suggest to young lawyers that they obviously talk to other people and stuff, but get a cadre of 2 or 3 mediators you feel comfortable with. It's more comfortable for you, and it's more comfortable for me. I know your tricks, Chris. I know whether to take.
I don't have any tricks, Barry. It's facts.
I know whether to take somebody's first offer. I got one particular client. I just know she gets serious at 12:30 because she wants to have lunch at 1. I just wait till 12:30, and I know that's her best offer, and that's it. But that's because I've done lots of mediations with it. It's almost a joke. She says 12:30. It's not 12:30. Just hold on.
For the roster, sometimes we do see, because the rate's so low, so some corporate parties want to effectively take advantage of that discount. They say, or their lawyer probably recommends to them, oh, well, you could get this discounted roster mediator. And so we want to use someone who's on the roster because of that discount. And so that's what we somewhat see. There might sometimes be a perverse incentive from the lawyer if a lawyer sees that if the mediations, if instead of 80% of your mediations, if they are subscribed to the idea that they want mediations to fail because it is better for them, whether or not they consciously believe that or not, you might choose roster mediators if you're not going to planning on taking it seriously. So there's a place for roster mediators if the parties really can't agree. Now, in employment and labor law, we are lucky that we are spoiled because there's a strong selection of labor arbitrators who also have experience in mediation. So Barry's also a labor arbitrator. There are a number of other qualified and great labor arbitrators. Now, you don't have to be a labor arbitrator to be an employment mediator, but it is a dual role often, and so you can often go to those labor arbitrators as sort of a pick-me-up. Now, not every area of law has that, but it has developed strongly in labor and employment because they have that med-arb history from being at the OLRB or being a labor arbitrator for unions. When they sit in a judge-like capacity, so they have that experience.
Right. So I'm able to talk about how, as a lawyer, this, and I can say as a decision maker, I can tell you that if I heard evidence like that, it would go this way or that way. I'm not your judge, but I do have experience in how judges think because I also act as one. And you're saying that it was your twin brother who stole the car, not you, may just not be very convincing, especially because you don't have a twin. I actually had a twin brother defense. I had a guy who alleged his twin brother was the one who was goofing off all day. And management questioned whether he even had a brother, let alone a twin. But anyways.
Well, I think that's a great insight, into the genesis of our mediation bench. That's great. Let's talk about the difficult ones, the 20% that don't settle. Cause is alleged.
No, that's not why. That's not why cases don't settle. Ask a different question.
Fair enough.
Why
there are claims for damages. There are contentious issues. Why don't matters settle?
That has nothing to do with why cases don't settle. Let me give you my little trilogy.
All right.
The things that don't affect chances of settlement. The amount of money at stake, completely irrelevant. You can spend more energy on a $10,000 case you can on a $100,000 case. That's almost irrelevant. Disagreements are legal differences. To some degree, yes. Factual differences, perhaps more. The most important issue defining whether a case is going to settle or not is the reasonableness of the parties and whether the lawyers get along. So you can have the world's simplest case and the lawyers hate each other's guts and or the employer despises the employee, whatever. They make irrational decisions. Those are the difficult ones. It has virtually nothing to do with the complexity of the legal issues in my experience.
I absolutely agree. I don't think the cause doesn't change the percentage. The amount at stake, I agree with Barry, doesn't change the percentage. Underlying disputes don't change the percentage. I mean, generally, probably two main things. I agree with what Barry said, but two main things out of that. First of all, is the plaintiff on, say, contingency fees, or they're independently wealthy such that they can actually afford to potentially keep going? If one of the parties does not have a capacity to be able to say no at the end of the day, then you're going to fall into the 80% really no matter what. And then second of all, is there a decision maker on the defendant's side who has some sort of personal liability or personal stake in the matter? So, did a defendant manager make a certain decision and that they have the ability to allocate additional massive amounts of resources from their company defending a decision that they made? And if they cop to that decision being a bad one, will they personally get in trouble or have some sort of problem? So it's very often an agency issue, at least some of the time, that, say, some manager is able to defend their decision with company money. But those are some of the issues that can come up, right? Like you do need unreasonable parties. I guess I'm just expanding on the unreasonable parties and the types that we tend to see. It's going to cost $100,000 to go to trial, but you could settle it for $50,000. It takes an unreasonable party to do that, but it's very often.
Oh, you got a rich guy who $100,000 is nothing, and he hates his guts, and he'd literally rather spend $100,000 to see that person rub his face in the dirt. I've met those people.
Oh, sure. Yeah. Small. We often see that as a small doctor's offices or dentist's office. How dare the receptionist of 24 years think that they deserve 24 months?
He came to my wedding. Oh, God, I hear that one all the time. So,
yeah.
In other words, it's the personalities that more often prevent settlement than the legal issues.
Right. I think that's where I was going with, sort of cause and damages. Those are those decisions that are hard to defend, especially if there's a factual basis for them.
Oh, that's largely often irrelevant.
I hear you, but the people who are invested in them are really invested in them sometimes.
Well, yeah, and that's something I look for too. So, for instance, if you're telling me if there's a crappy employment contract, and we all know it's illegal, okay? But I show up at the mediation. The worst case scenario is a junior shows up and tells me that the senior partner wrote that piece of crap, okay? That junior is going to have a hard time going back to his boss or to the client saying, oh, by the way, you spent a lot of money on a contract and we screwed up and therefore you should pay money. I look for the ability on the defense side usually. It's not a plaintiff side. Plaintiffs can't afford to lose, frankly. They can't afford to be stupid. Plaintiffs can't afford to be stupid as much as defendants can afford to be stupid because it's not their money half the time. So I look for who's going to look stupid here and try to blame it on somebody else. Like I just did one the other day where the plaintiff's argument was the defendant had breached the human rights and they're horrible and everything. And that's just not going to sell back at the corporate head office. I'm not going to get anywhere telling the president he's a racist. On the other hand, notice periods, they're very expensive. And the president doesn't know from notice periods. So we just up the notice period Stop talking about racism. Everyone gets their money and everyone's happy. One of the problems with lawyers generally, is they somehow think that throwing insults and dirt at someone will encourage them to open their wallet. It usually encourages them to do this. And the same thing on the other side. The defendant wants to beat down the plaintiff, so let's make up BS allegations of cause, or let's criticize. I had one the other day, I couldn't believe it. The failure to mitigate was in 6 days in February, she didn't look for a job. They were 4 Sundays, but she didn't count those. So therefore, the notice period should be reduced by 6%. In other words, just stupid, silly arguments. And part of the problem is managing client expectations. We make arguments which we know are stupid and silly. The client doesn't. You tell the defendant going in, you got a great case for cause, and I tell them, you haven't got anything for cause. And then all of a sudden they have to move. So one of the other reasons, long story, one of the other reasons mediations fail is because the person has to come too far. And that's usually because the lawyer, in my opinion, is not managing the client expectations. They come in thinking it's $1 million, and they're told, well, $15,000 is a good settlement. What? That starts on day one, managing the client's expectations on both sides.
Right. So there's 2 more things. I had a whole host of more questions, but we're coming up to the end of our time. I wanted to ask quickly thoughts about the evidence at mediations. Currently, the rule provides that you have to deliver the documents upon which you rely. Is that correct?
Not at a mediation, you don't know.
But what about, so what is the rule for the documents that have to be disclosed, 1, and 2, is it better to wait till after disclosure to have your mediation so that you're certain, at least, you've got an affidavit of documents, I suppose, that suggests that you have a complete record? Thoughts?
Well, there is no rule requiring you to produce documents at a mediation. There is a rule that you have to produce your affidavit of documents. So your question is, do you do it before or after? I think it depends on the case. In a notice case, who cares? In a notice case, there's not a lot of documents that the plaintiff needs. Not only that, if there is a document that you need for the mediation, you just write to the other side saying, listen, to have an effective mediation, I'm going to need to see this. I don't need your whole affidavit. Don't waste your time. Employers routinely will say, if we're going to have an effective mediation, you have to show up with your mitigation log. If you don't, we're not paying you a dime. So rather than insisting on full production, think, what do I really need? So for instance, in a typical case where we're trying to figure out whether the guy's bonus would have gone down during the notice period, it would be perfectly appropriate for the plaintiff to write to the defendant saying, listen, if you're taking a position that bonuses were generally reduced, please show up with some information where you can show that, because I'm not going to take your word for it. So if you need selective information, just write to the other lawyer or wait for the affidavit documents. Same thing with discoveries. Some very good lawyers choose to, in a case for allegation of cause, there's a good rule to say you do it after mediation. Why? Because you've pinned down the plaintiff or the defendant with their story. Too often you show up, there's a just cause allegation, the guy stole something, say, and at mediation they come up with some stupid excuse and it fails, so they think, okay, I'll come up with something else next time. Well, okay, it wasn't me, it was my twin brother, I didn't know what I was doing. So there's a good argument to say you do examinations, pin the plaintiff or the defendant down to their story, and then they can't wobble when they get to mediation. So it's a strategic decision based on what you actually need. And the timing, is it worth waiting 6 months to get a little bit of information? Can you do the mediation without all that information? That's all the decisions that go in.
Andrew, thoughts from the trenches?
Yeah, well, each party chooses to bring the documents that they believe best represent their case, and very often at mediation, because it's not like a curing, sometimes they'll say, "Can you go, well, we have a dispute about your bonus. Can you go and pull up your T4 from last year? Let's go get this document now. Let's email the HR person and get that document if you say that that's relevant." So you can deal with all these issues. At the time, you have 3 hours or whatever, so you have the time if they're so important. You have that. in terms of the timing, so that's usually it. I mean, one thing I guess I want to note on that quickly, and this is just behind mediation theory. One of the reasons behind why that works, in my opinion, is because what happens at mediation effectively, each side takes discounts, but those discounts importantly don't have to be about the same thing. So a defendant might want a discount because the employee failed to mitigate. Now, the employee, from the employee's perspective, they might say, I'm not going to give a discount at all for failure to mitigate. I'm going to win that. I've won that every time I've went to trial on the failure to mitigate in terms of not applying hard enough that the client's too lazy. That doesn't really matter. Because, say, as a plaintiff, I might be willing to take a discount for a different reason. Like my client who's been unemployed might want the money sooner. And the defendants, I mean, some defendants are honest about it, but many defendants are reluctant to sort of say, look, like, wouldn't you rather, it's a concept in psychology about hyperbolic discounting, $5 now versus $10 a year from now. People take the $5. Don't you want the money now? Don't you want it sooner? The discount doesn't have to be the same thing. You just need to overlap the Venn diagram. So that's the important aspect, and that's why, I might not be willing to take a discount because of that failure to mitigate or because of a clause or because of any number of reasons, but we might be able to be willing to take a discount because my client also just is really stressed about the experience and just doesn't really want to go to court and really hates the idea of going and testifying in court. But that's not a legal issue. That's just a them issue, right? So that's the second thing. And the third is in terms of timing. I mean, I'm a fairly large proponent of mediation as the first step, not examinations. I might have to disagree with Barry on that one. Although
plaintiffs almost never want to do examinations.
No, but part of the reason is just how employment works. I think it is an employment thing. So in personal injury, I'm given to understand of practice in personal injury. I haven't in more than 10 years. But you have the exchange of expert reports. So their sequence is that you have the pleadings closed, then you have you have the pleadings, then you have the examinations, and then you have a mediation, and then you exchange expert reports, and then you have a pretrial. But in employment, we don't often have expert reports. I have had some cases, but very rarely, probably less than 5%, probably less than 2%. So the problem is then if you go to a mediation, the next step, if you do discoveries first, then you go to mediation. The next step after the mediation is a pretrial. So you're then aligning the two opportunities to negotiate right beside each other and effectively making them not very useful because you don't have much more to talk about. There isn't really much new information. Whereas if you align it so that you have mediation first, not knowing what's going to happen to discoveries, you try your best, maybe you can resolve it, maybe you can't. If that fails, then you go to discoveries, you do all those discoveries, you get all those documents, then you set the matter down for trial, then you go to the pretrial. At the pretrial, there's something new to talk about. The plaintiff did well, the plaintiff did poorly, the accused, the manager did well, they did poorly, the documents are different. So you have something else to talk about, so it gives you two opportunities rather than just duplicating the opportunities. And so when you look at the sequence that way, at least for us, my strong opinion is that it makes the most sense to just go to mediation because 80% still settle no matter what, and otherwise you're really decreasing the chance of having a meaningful pretrial with no additional new information. If Barry can't settle the case, having a judge and an associate judge, they're great. They have a different skill set they can impose, but you already have a private mediator with all the same facts has already taken a run at it. They don't have the same perverse incentives necessarily as well to try to get the resolution other than the free up court time. So that's just, my opinion. We're happy enough. We always say, we're not going to insist on having a mediation first because we think that might show weakness. So we say we're going to discover, we'll do discoveries first. Sure, drives up costs, wastes all of our time, but we'll do it. We don't care. Otherwise we seem weak that we're demanding a mediation first, and it shows the wrong impression to the other side that we're scared about a case and we'll just take anything. And if we give that impression prior to mediation, they'll lowball us, then the mediation fails. So we'll say, confident in a case, you want to go to examinations is fine. But I think it's...
The other thing, too, is, and I say this to plaintiffs all the time, well, the other side insisted doing discoveries. Yeah, okay. So I did mine. Why? If they insist on doing your client, fine.
To highlight to their manager how awful it will be if they have to testify later. Yeah. And how silly it is that they were forced to go through these things, and that maybe they'll choose not to in the future. Because if you just let them take a run at the plaintiff without, shows them, look, trial's not going to be fun. What is it? The Supreme Court said, it's not a tea party. I think that's a bit denigrating towards tea parties. But at the end of the day, it's maybe a U.S. Tea Party where they threw the tea in the ocean.
Boston Harbor.
Yeah, it's a different Boston Harbor one. But look, it just you want to do that, fine, because otherwise defendants will often take we've had circumstances they say we want to examine, we say fine, then we'll both examine, and then they say, okay, forget it, we're not going to examine because their client doesn't want to. They don't want to come in. The CEO of their company or whoever it is, maybe just pick the CEO. They don't want to get examined. They don't have to answer all these nasty questions and all these sorts of things and have feel like they're insulted and their decisions are being attacked. So then they just say, okay, fine, we're not going to examine either. That's why we do it, Barry.
I think it's remarkably helpful to have the management witness have to articulate the unreasonable positions on the record, in the formal setting of the examination. Like that takes a lot of the starch out of a lot of tough guys.
Well, the flip side too is your old client thinks that it's a cakewalk, and all of a sudden, oh God, they're asking me all these really tough questions.
Right, and I don't like the way the answers sound. I don't like what I'm seeing. I don't feel good about it. People know, right? They know when they're setting themselves up for failure, and so it's easy. There's a lot of power in the word no, until you've got to articulate it, or you've got to express it more broadly, or you've got to build consensus, whether it's in the court of public opinion or in front of a judge. And I think Andrew's onto something there. I also thought the idea of discounts for differing reasons, that's very powerful, and certainly that's been my experience on many occasions. It's a great explanation. So thank you for that.
I want to add something else. Sorry. So procedurally as well, if we haven't if they've examined the plaintiff but we haven't examined the defendant, then we go to the mediation. There's more of an incentive on the defendant to potentially fail that mediation, not bring their top dollar that's required to settle the mediation, because they sort of know that if the mediation fails, then it's going to be further delay in the future. The plaintiff won't be able to just set the matter down right away. If we've done the examination, we can theoretically, the day after the mediation, if we have all the undertakings that we need and we're just going to rely on adverse inferences, the day after mediation, we can set the matter down for trial, or frequently, as our office does, show up in court and ask to be put on the rocket docket and ask to be given a summary or expedited trial date within the next 6 to 9 months. And then all of a sudden, the defendant is saying, well, we want to delay because we'd rather not pay. Of course, defendants don't want to pay. They probably have a line of credit they're paying 8, 9, 12% on. It's a business line of credit, right, or whatever. They'd rather not pay this money and they'd rather pay it in the future. If they're told you're going to go to a hearing, the next step's going to happen pretty fast, that's going to be another incentive for them to get it resolved and to bring the top dollar at mediation, offer that $50,000 instead of the $40,000, or the $500,000 instead of the $400,000. Yeah. And otherwise, they say, well, if what's going to happen after mediation is that the plaintiff's going to write to us and say, we're upset and we want to schedule our discovery, and then we're going to pretend to be busy for the next couple of months, and maybe that happens 5-6 months from now, and then it gets set down for trial a year from now. We've got time, let it go. And most people don't ask for interest because the interest rates are low. So, I'm just saying another procedural reason is that anything to get one step closer to trial is better because that focuses the mind, especially for defendants. It focuses the mind significantly.
I've got one last question, and then I think we're out of time for today. I'm just going to throw this out there. I've heard this said a few times, a few different ways, but the gist of it is settlements get paid and judgments get enforced. Do you think there's any truth to that? Do you think there's any value to that mediation brings? For example, a settlement, you're going to receive the funds, whereas in a judgment scenario, you may find yourself with a lengthy enforcement chasing your money.
Absolutely. As I say to people, I said, you have two choices. You can take this amount of money and actually spend it, or have a judgment, and if you photocopy it a whole bunch and glue it together, you can make it into wallpaper. I explain to people that a judgment is a invitation to pay. And most lawyers don't have a clue how to do a collection case. So if you've got a scumbag defendant who will incorporate a company on Monday and a new one on Tuesday, like my son had in a lengthy case against a highly disreputable company, and I can't remember his name right now, collection is a nightmare. If you're a scummy person who has no conscience, you can pretty well avoid paying most debts. So the ability to make sure you get the money in 30 days as opposed to, gee, I wonder if I'll ever be able to collect on it, has a massive appeal. And that's used often by defendants who use poverty as a defense. We may not be in business by the time we get to trial. So you want to take 50 cents in the dollar now, or do you want to risk it we probably won't be around.
So that's what you're hearing in mediation. I'm wondering what Andrew's
Totally.
experience in the trenches actually is.
Look, some people, some people plead poverty. I just say, show me the financial statements. I'm able to very quickly review your financial statements and determine the actual value of your company. They then invariably do not give me the financial statements, and then I say I'm going to take a 0% discount on you being poor. I don't have financial statements. We'll chase you to the ends of the earth. And but again, we don't have to have the same discounts for the same things, right? So my client wants the money fast. They say it's poor. Just because we take a 0% deduction on that doesn't mean that we can't have a zone of settlement. My experience is a bit different. I have a bit of a different philosophical view on this. Interesting enough, I think actually everything is settlement. My point by that is if you actually look at the trial as being along the continuum towards settlement, that a trial is actually just a stage of settlement. So, for instance, you could have a trial, you go to trial and you determine maybe some but not all issues, or you go to trial and then maybe there's an appeal, and then you maybe have a settlement of that appeal. So even the enforcement procedure is a possibility of settlement. So, we got a judgment, for instance, and then a company didn't pay. We went and we had the sheriff seize the vehicle outside of their office, their factory, their work vehicle. So the controller calls me up and says, we need the truck, it's worth $200,000, get it, we'll send it to the wire right now. I mean, that is part of the settlement process. So suddenly they were willing to pay that judgment. So it's all just a spectrum. It's not about settle, not settle. Every single case settles. Like, that's just how it works. It's just about what tools do you need to get to that settlement. So, someone's going to pay voluntarily. Very, very few cases. I can think of very few where you actually had to seize all the money. Once someone gets a garnishment order and they can't resist it and they can't hide their money, then they're going to say, fine, let's come to an agreement. And then you still have a settlement. It's still a settlement. It's just that it narrows what you're fighting about, that eventually if you have to go to court, right? You can still settle. Sometimes you go to the Court of Appeal or sometimes the Supreme Court and they're still fighting about some of the individual issues about how to calculate the value of someone's benefits. Like, you get a judgment and then you're still fighting about those calculations and you're fighting about costs. So it's almost always a settlement. It's just that certain options are eliminated. The zone is getting smaller and smaller over time. Almost all payments are consensual. But with the stick coming from the sheriff, the police, coming from the government, being found in contempt of court if you're not willing to give over your documents. So those sticks eventually become more and more harder, and so the zone that people are willing to settle for becomes less and less over time.
I had a case involving a very rich individual who fired his butler. It was like watching Downton Abbey, but anyways. And they despised each other to the core of their being. And the settlement, the employer was not prepared to go beyond $20,000. The plaintiff insisted they would never take less than $25,000. So I went to the rich guy and I said, how quickly could you get to $20,000 here? He said, I don't know. I'll just call up my secretary. It'll be here after lunch. Why? Okay, just leave it with me. So I went back to the plaintiff's room. I said, go have lunch, come back, and there'll be a certified check for $20,000 on the table. Is that good enough? Grabs it. Grabs it because he didn't believe that even if they settled for $25,000, the guy would pay. So sticking money, and literally the guy went to lunch, came back with a certified check, and it settled. So the knowledge that you're going to be paid as opposed to, am I going to have another fight, can have quite a significant value. So one of the things I do often is encourage an employer to say, in that sort of case, it's Monday, the money will be in your lawyer's office by Friday. Oh, not even 30 days. And that can close a gap sometimes.
Guys, we're coming to the end of our time. I want to thank you both. I could listen to you talk about mediation all day. Fascinating insights.
I don't have all day, so don't.
Yeah, fair enough. Fascinating insights. I really enjoyed it. I learned a little bit today. I learned some things I didn't expect to learn today. That's fantastic. And I guess, listeners, thank you for tuning in. If you like the episode, subscribe, leave a review. If you've got a case you'd like us to take a peek at, send it in. Or if you've got your own story of workplace drama you want to share with us, email us at watercoolerjustice@gmail.com. And until next time,